Call now cause number PD 067722, Larry Jean Park versus the state of Texas. You can proceed. Yeah, that's okay.
One of the problems with my age, I guess, is may it please the court, Ron Goranson, Dallas, Texas. I'm appearing for the appellant Larry HART. The defendant was charged with capital murder. Basically, the driver who took part in drove others to an apartment complex, and it was a burglary. It went bad. It ended up becoming, the complainant was shot and died. Everybody fled the scene. Trial jury convicted the defendant of capital murder. The state did not seek the death penalty, so it was an automatic life sentence. The appellant appealed to the Dallas Court of Appeals. The decision came down 2-1 against the defendant, or appellant. Rehearing was denied 2-1 also, and a motion for rehearing in bank. There were 4 dissenting justices in the denial on that, the request for rehearing. The issue is with the introduction of 2 rap videos and 4 portions of the appellant's Facebook page prejudicial. I'm asking this court to establish a rule in these types of cases where you're dealing with artistic impression, rap music specifically, but it's a broader rule that includes all types of artistic impression. Basically, it's not admissible and it can be prejudicial unless it's truthful narrative of the actual facts of the case.
Counsel, go ahead.
No, you after you.
I was just gonna say, so why do we? Let's assume that this was truthful. Does that still mean that if everything he said was ascribed to everything he says in the Facebook post or in the videos is a truthful narrative of his life? Does that mean it's not prejudicial?
No, not of his life, of the case.
Of the case.
Yeah.
Okay.
Stated differently, how far do we let prosecutors use one's own culture against them?
Well, counsel, let me ask you this. Why do we need a rule? Why do you feel like we need a bright line rule? Why can't it just be case by case?
Well, it'll always be case by case because the facts of each case will always be different. But I think if this court establishes what I'm asking for is a bright line rule, is it at least will subject the offer, the proponents to make sure that what they're offering is a narrative of the facts of the case. And also everybody is aware of how prejudicial this type of evidence is. I cited in my brief the studies, the dissenting judge at the Court of Appeals referred to even more studies than what I quoted in my briefs. And the evidence is clear that this type of evidence is extremely prejudicial.
Okay, well, that's kind of what I'm getting at. What is it about this information that makes it prejudicial? What are trial courts supposed to look at to determine how far away you've gotten from the narrative of the case or something to know that this is something that's unduly prejudicial and that the risk of undue prejudice or unfair prejudice is so great that it overwhelms the probative nature of the evidence?
Okay, how do I explain human nature? I don't know that I can do that. But what I'm suggesting is the research suggests that basically, to be blunt, that white people are threatened by the message in rap music. Okay. And that's what the studies seem to show. But it might not just be white people, it's all people are threatened by it.
I appreciate that. That raises 2 questions for me. First and foremost, though, the studies that you're relying on, were those things that were presented at the trial level? Like you're mentioning the discussion about, and I read the dissent from below. It's very thoughtful. But how much of that information that the dissent is relying on, these articles, these papers about the reaction to rap music, how much of that needed to be in the record before the trial court to make the trial court decision? Can we just rely on the fact that these papers exist, or was there some obligation on the part of the state or the defense to have presented this to the trial court to make the decision?
If you've read the opinion in the Williams case, the magistrate's opinion from the federal district in Arizona, that ended up being like a 3 or 4 day hearing with expert witnesses coming in to testify, the studies put into evidence. I don't think that's a pragmatic way of approaching this, how trial cases are tried in Texas or any place really. Is that we don't have the ability to have that type of hearing every time it comes up. But I think that what the basis of a bright line rule would do would be to make sure that the judges focus as to basically the racial implications that come in because of this type of music and how it's perceived by other people.
Okay, well, that's another point. It seems like you're affirmatively asking us to make a ruling that is race-based and come up with a rule that is race-based. Does it seem like we can do that?
Well, first off, I mean, if you're going to say that it is race-based, but that's where the prejudice is because of it. This is with reference specifically to rap music, is how extremely prejudicial it is. But I think you're ignoring reality to say, well, this is just music and the jury will consider it like that. That's not the way juries look at this type of music.
Well, I'm not asking, you're taking me wrong. I'm not saying that, I'm wondering why you feel that we can or should limit it to this one style of music. I mean, you can find examples from all sorts of music that might actually offend people, and not just white people, but people from all different races. And that if someone is a fan or listens to a lot of different types of music, the fact that they listen to a particular type of music might scare a jury.
I think in my brief, I mentioned country music, the Kingston Trio.
Right.
You could even go further. A woman quoting Lady Macbeth about killing a child. I mean, you can go into all. That's why I was asking. I used the term literary expression as opposed to just limiting to rap music. I think rap music has a higher level of prejudice than country and western, and the Kingston Trio, basically, or Johnny Cash.
But what is it? I mean, that's what I'm saying. Your point is that is it just the rule is because rap music scares people? What is it about the rap music? What is it about introducing the rap, and particularly with regard to this case, that makes it so that that there would be a danger of unfair prejudice? Is it a confusion of the issues? Is it because the jurors lack context? They don't understand how to interpret what they've heard? Is it that the content of the message is so inflammatory that it makes you ascribe motivations or bad behavior from a literary work to the actual actor? What is it that trial judges are supposed to consider when determining whether something is unduly prejudicial?
All I can say is the studies show that when, there's one study in the Arizona case where the people in the study were more influenced by the fact that the case involved rap music than the fact that the person was charged with murder. So I don't know how I can explain it other than the population at large is unfamiliar with rap music, where it came from. It's actually a social protest type of music.
I got it.
They just don't understand it. They interpret the words literally rather than figures. That's the best answer I can.
Okay.
So is it the music? Is it the music itself? Is it the music plus the video? Like, what do you, like? Let's just say in this case, the state had just played, for whatever reason, they had a recording, sound only, no video. I mean, would that have made it less prejudicial?
I think the way the videos are make it far more dangerous in the jury box. Let's put it that way. I mean, I thought about opening up by promising y'all that I wouldn't do rap or wouldn't try to sing. But
Feel free.
No, I can't.
I liven things up.
I'm not
Now
about
it's time to
step
pass
in.
the mic to you.
I don't have the talent, first off, to be able to do the quick rhyming. I mean, I'm amazed at how they do that. But the visual way they do things, I mean, the quick movements, the everybody in tank tops, and it's a visual thing that basically scares people. And they're not listening to the message. They're using other senses.
But didn't you just hit on something that the state is going to argue, that basically you say you don't have the talent to put together those words and that quickness? Isn't that exactly what the state is trying to offer this to show, is that this defendant is sophisticated enough to be able to flow, to be able to put words together, to sort of respond, that he's not some, you know, naive fellow who fell in with the wrong crowd. This is the lifestyle he's chosen. And this video and these lyrics and this music and the posting tends to reinforce that he is very much of this world, that he claims that he was just a bystander in.
I thought we were supposed to convict him for the offenses
I agree.
he's alleged to
I
commit,
agree.
not the person or the where he lives. I mean, the world that he lives in. You know,
But
so I thought-
being able to do rap does show at least some level of mental sophistication that kind of rebuts the idea that the state, or that the defense was trying to present.
I don't think that's accurate. Anybody can lip sing. I mean, that's basically what one of the videos was. It wasn't his words. He didn't make up, he didn't write the words. He was lip singing to what somebody else was doing.
Well, that brings.
Isn't Judge Newell pointing out, though, that it takes a certain level of intellectual firepower to be able to do that? Not everybody can do it. You can't do it. You just told us.
I can't dance either, but that's
You and Genesis.
The jury had far, as Judge Reshik points out in her dissent, the state had far better evidence than going into a rap video to show that his presence in front of the jury, they had a videotape of his oral statement to the police before. I think that evidence would be. You're not injecting into the case these cultural issues. And that's what I think our point is that in effect they were trying to convict him for who he was rather than what he allegedly did. And I mean, it wasn't a whodunit. I mean, he stated he took the people over to the apartment. So that, I mean, but to say that because somebody can sing a song, that makes them have the intent to commit an offense, I don't think we want to go down that road.
But
And I think that's what we want.
But it wasn't offered. It was not offered for intent. It was offered to rebut the defensive theory.
Yeah, but look at how they used it in front of the jury.
That's a different thing than what it was offered for. That's right.
Right.
Okay.
Because what they offered it for, if they'd limited it to that and requested an instruction that this evidence is only limited to such and such.
Was there an instruction?
No,
Okay.
neither side requested it. So, I'm kind of the school that if you're a proponent of evidence, that you're the one that should be asking it. It should be limited to what we're offering it for. But that's not what the rules are in Texas. But if you want to try to protect your case, it seems to me that's what the state should have been doing in this case. We're only offering this for this. But that's not what the question showed. They were offering to show he's a criminal generally, that he possessed a gun, that he ran a something house.
Right. If he's a Kenny Rogers fan, it's questionable whether or not he would show karaoke of him doing Kenny Rogers. The state would want to put a karaoke of him doing Islands in the Stream.
I mean, there are references to literature. I chose to use, the Kingston Trio and Marley, but I mean, you could go any place, almost
Was a
any
limiting instruction given?
I'm sorry?
Was a limiting instruction given?
No, not at all. Again, I think,
Was it requested? Sorry to interrupt you.
No.
Okay.
I did not, I don't recall anybody requesting a limited instruction. I'm pretty sure I would have put it in my brief had somebody done it.
Right.
Yeah.
Thanks.
So, I've got 5 seconds. I don't have anything I can say that quick. So.
Same time for rebuttal?
5 minutes. For
Okay,
rebuttal.
thank you, Kim.
Thank you.
May it please the court, my name is Grace Shin, and I represent the state of Texas in this PDR. We are here today because the appellant wants this court to review an issue that was never presented to the trial court and never considered on the merits by the Court of Appeals. Appellant wants this court to reverse the judgment of the Court of Appeals based on an argument that was not preserved for appellate review. At trial, appellant objected to the rap evidence on the ground that he hadn't written the rap lyrics, or that if he had written them, there was no evidence as to how long it took him to write the lyrics. Basically, appellant was saying that this evidence was not relevant to show what the state claimed it showed.
Did he make a 403 objection?
He did. He claimed the evidence was unduly prejudicial because it glorified criminal conduct. He also claimed that the evidence was not relevant because he wasn't actually rapping in the videos, but he was merely lip syncing. So those were the extent of his objections at trial. Nothing about these objections apprised the trial court of the argument that he ended up presenting on direct appeal and the argument that he presents now before this court. And those arguments, as this court has just listened, are that rap music is different. It's a special genre that's metaphorical, but often construed by juries as autobiographical. On appeal, and in this court, he argues that the rap music has cultural aspects, and when introduced in a criminal proceeding, it has a tendency to impact a jury in a racist manner. On direct appeal, he argued that because of this rap evidence,
But
he was
counsel-
convicted.
Counsel, I mean, I appreciate that. I appreciate the idea that, and I took issue with defense or with appellant's counsel on this, that he's making an argument about some sort of specific cultural thing regarding rap that we should do. But is there an argument based on just the sheer amount of different kinds of information that was presented? Because it's a video, because there's a video of it, we're talking about there's posts on Facebook, there's also lyrics to a song. Like a large amount of information might have actually been unduly prejudicial because it confuses the jury. It can inflame the jury, regardless of the cultural aspects to it.
I mean, there's always a little bit of danger for prejudice, and it was actually relevant to the purpose for which the state offered it. In that sense, it was prejudicial, but not in an unfair way. And to the extent there was...
Okay, so what makes prejudice unfair?
When it has nothing to do with the guilt of the defendant, but something else that's not based on the facts of the case or the allegations. Something
Isn't that why he's arguing that you should draw the line at saying the lyrics and all this information goes specific to the case at hand? The fact that this guy is in a rap video with a bunch of people, and the fact that he's maybe quoting Young Thug, has nothing to do with the trial.
And that wasn't the purpose for which the rap evidence was offered. Mm-hmm. It was offered because the appellant took the stand, and he testified basically that he had trouble using and understanding words. He had difficulty with language.
Yeah.
He also testified that he's from a small town, and he just gives rise to people because he has a kind heart and an open heart. He's friendly. That was the evidence he presented.
Okay,
he
so counsel, how does the admission of the videos rebut his testimony that he's a friendly person? I mean, you're certainly not up here saying that anyone who lip syncs an NWA song is an unfriendly person.
No, that was
thank
just,
goodness.
It wasn't
Really, I'm off the hook.
Yeah.
It wasn't necessarily to show that he wasn't a friendly person. It was offered to show that he wasn't that naive about criminal subject matter.
But isn't posting? I mean, I have a 13-year-old daughter, and I don't think, knock on wood, that she's posted anything on the internet in a video manner. I mean, doesn't that kind of show his naivete that he is actually posting this stuff on the internet?
I mean, I'm not sure how that goes.
Like,
I
I
mean,
have such poor judgment that I'm going to post videos of myself singing about guns and drugs. I mean,
I mean,
doesn't that
that's
seem
a
little
separate
naive?
matter. I mean, everyone should really be careful about what they post on social media. That's public. But that's kind of a side issue. The real issue is, what did the content of what he posted show, and how is that relevant to this case?
Well, I mean, doesn't it? I mean, one argument is that it shows that he spent hours and hours rehearsing the ability to lip sync along with these songs.
I mean, that's possible, and he could have been questioned about that by his counsel if his counsel was concerned about that. So it wasn't as if the state introduced the evidence and that was it. The state cross-examined him on the evidence, and then his attorney questioned him about it. So there is room to flesh it out. And these are all valid considerations, but it's also the trial court's job to weigh these considerations. And the trial court ultimately determined that the evidence was relevant to the purpose for which it was offered. And the trial court probably considered its prejudicial effect too, but likely determined that it wasn't substantially outweighed by its probative value.
Well, how strongly does this evidence advance the theory for which it was offered?
I'm not sure how strongly it does, but it is relevant, as the Court of Appeals recognized.
Right.
Relevance is a very low bar. If it has a tendency to even make a fact more likely than not, then it's relevant. So regardless of the strength, it did show.
So 403 doesn't consider the strength or the probative strength of the evidence?
403 does consider that. It's one factor.
Right.
It's one factor.
Right.
But then there are other factors, such as the tendency to confuse a jury, how long it took to develop this evidence, and many other factors. And in this case, the facts of the case were largely undisputed. It was undisputed that his friend, little partner, asked him to drive him and some friends to his uncle's home so he could break into his uncle's home. The evidence showed that he drove his accomplices to the uncle's apartment parking lot, drove around, made sure the car was there. And this was around midnight, so a time when people would be home. And then he waited while his accomplices got out of the car, and then eventually ran back into his car, and he drove them away from the scene. He also later picked up the other two who had driven away in the victim's car. Really, the only issue was, did he understand what little partner was saying when little partner asked him to drive him so he could break into his uncle's home? And he gave wavering answers when asked about this. Right. So the videos, they showed more likely than not, when little partner asked him to drive him to his uncle's home to break into the home, more likely than not, he understood. He wasn't so lacking in language abilities that he couldn't understand the simple request.
Okay, so the videos help show that he did understand this request. If that's the case, why do we have to have a whole discussion, a side discussion about whether he's lip syncing or actually wrote the lyrics? I mean, isn't that distracting the jury from the charged offense?
Well, no. First of all, the whole argument about lip syncing that was raised by the defense at trial, I'm not entirely sure how that goes to the purpose for which the evidence was offered, but the state did offer the evidence to rebut his characterization of himself as slow and not good with words. He said, I'm not good with literature, I confuse words, I don't always understand what people are saying.
Right.
So if he did write the lyrics, well, then more likely than not, his use of words and language isn't as bad as he claims it is.
What you see, my point is that by putting this evidence in, now we have to have a whole side discussion about whether the guy wrote it, whether he was lip syncing. All those have nothing to do with whether or not he's guilty of this offense.
They don't show that he was guilty, but they go towards, he kind of opened the door by testifying about how slow he was.
Yeah, which is why it's relevant.
Which is, I'm sorry?
Which is why the evidence is relevant, because he opens the door. I get it. But I guess my point is that the 403 analysis has several factors that you weigh, and the trial judge is supposed to weigh, and so I'm trying to gather from the advocates, what is it the trial court is supposed to be looking at? What should the trial court have considered when they see this in the future? When they see someone who wants to rely on a Carrie Underwood song or something.
I mean, mainly the strength, the probative value of the evidence and weighed against its prejudicial value, unfair, against how prejudicial it is. So you're weighing those two main considerations. And in this case, yes,
And
it
the
was
time it takes
probative.
to develop the evidence.
Yes.
And,
I mean, it's not a scientific formula, but there are factors for the court to consider. And, you know, courts have held that in close cases, they should presume that the evidence is more probative than prejudicial. And in this case, based on the record, for the trial court to admit this evidence over the appellant's 403 objection was not so outside the reasonable zone of disagreement that it was an abuse of discretion.
Counsel, just a few minutes ago, you mentioned the word a little prejudicial. Is that a fair wording of what you, how prejudicial you think these videos were?
I think there was some prejudicial effect, but I also think the trial court did not abuse its discretion when it weighed the prejudicial effect against the probative value and other relevant considerations.
So you're saying it was more than a little prejudicial?
Well, I don't know how exactly to quantify, and it's not my job to quantify because we defer to the trial court under an abuse of discretion standard. The only thing we ask is, did the trial court act with reference to some guiding rules or principles? Was the trial court's action arbitrary? In this case, even if one court might disagree, even if another judge might disagree, somebody else might decide, well, what the trial court did was reasonable, because even though there is some prejudicial effect, it's not substantially outweighed by the probative value of the evidence.
And also, you mentioned the facts of the case a few minutes ago, and it took several sentences. And in my opinion, that's a really strong case. Wouldn't you agree?
Yes, it's a strong case. I mean, really the only thing was,
very well would have got a guilty verdict without this evidence, without these videos.
okay.
They were strong. I've tried a lot of cases myself. That's enough to be proof beyond a reasonable doubt.
Yes, I mean, we had his recorded interview, we had surveillance videos. I mean, he basically admitted to his involvement. But, you know, he also presented himself as slow, and there was a certain point when the trial court called a recess to ask about his competency. Whether or not that was real or feigned, I don't know, but he did create that issue. So it's possible the trial court decided, you know what, it's only fair that the state gets to also address this issue. He took the stand, he opened this door, and you know, with the Facebook records, for instance, the state initially offered thousands of pages of records. It ultimately only used 4 pages, and each page, maybe one sentence was highlighted. So even the amount of evidence with respect to the rap wasn't substantial. It was only a fraction of the state's case. So those were all considerations that the trial court could take in its 403 analysis. And the majority of the court on appeal held that the trial court did not abuse its discretion under 403 in letting it under 403.
Counsel, how do you feel about the fact that, I mean, yes, it was 2-1, but how do you feel about the fact that even the two basically said, please don't do this?
You know what? I don't disagree. But it is an abuse of discretion standard, and based on the record before the Court of Appeals, based on the arguments that were made, based on the evidence, based on the applicable rules, the Court of Appeals did not act outside the zone of reasonable disagreement. Reasonable minds can disagree. Even on appeal, you had a 2-1 split. People disagreed. It doesn't mean the trial court abused its discretion. The trial court abuses its discretion if its ruling is outside the zone of reasonable disagreement and if it acts without reference to any guiding rules or principles. And that's just not the case here. And you know...
Well, counsel, I mean, that's, I guess, the thing that I'm concerned about, which is why I've been asking for what we are supposed to consider, or repeatedly asked what we're supposed to consider when determining whether there's undue prejudice, is that it starts to sound like to me from the arguments I've heard, the argument here is about whether this is relevant. And it seems like everyone sort of agrees that this is relevant. That's only the first part of the inquiry. And that means if they're not doing the 403 analysis, are they relying on, are they following, Are they making an arbitrary ruling? Are they just basing it on relevance and not doing the full 403 analysis?
First of all, I don't know if everyone agrees that the rap evidence was relevant. I believe at trial and on appeal, the argument was that the evidence was not relevant, but for different reasons. There was one reason presented at the trial court level and another reason presented at the Court of Appeals. With respect to the 403 analysis, are we reviewing the 403 analysis conducted by the Court of Appeals? I'm not sure I entirely understand.
Well, are we supposed to, what are the things that we're supposed to consider to determine whether the trial court actually did the proper 403 analysis? How do we say in the future when something like this comes up, this does or doesn't violate 403? Or doesn't run afoul of Rule 403?
As far as I know, there's no case out there that gives trial courts certain formulas to follow or certain findings to make on the record.
Well, we've hit on several of them, haven't we? The need for the evidence is one, the strength of the evidence, the danger of unfair prejudice.
Right, and
the issues.
there's a plethora of authorities out there on relevant 403 factors. Sometimes courts of appeals consider only some of the factors. Sometimes they consider every single factor listed in opinions. It hasn't been a scientific formula. It's a case-by-case approach.
Sure.
So, and that's and it's hard to really, unless the trial court makes findings and explains its 403 analysis, the best that the Court of Appeals can do is just look through the record to see if the 403 balancing considerations were done. And in this case, there's enough in the record for the Court of Appeals to conduct a 403 analysis, whether it's applying 2 or 3 factors or all of the factors. But it really is a case-by-case approach when you read the opinions on Rule 403.
Was there other evidence that the state could have resorted to in order to demonstrate that he wasn't slow, as he suggested?
That's not apparent in the record, so I don't know.
Which kind of leads me to, I mean, it feels to me that one conclusion one can draw is the state found this super fun evidence, and they were going to use it however they could. And the minute he said, "Well, I just don't understand words very well," they went, "Aha, it's coming in." And especially in a non-death capital case where there's only one phase, there's not going to be a punishment phase. If he's found guilty, it's just going to come in. So why shouldn't our court just draw the conclusion here that, like Judge Urey sort of intimated that like they didn't even try to find any other evidence of his ability to use language.
The record is silent on that. We don't know that they didn't. It's
Well,
silent.
I mean, but the fact that they did not have any other, I mean, this seems like a really long way to get to he understands language. Like, instead of calling his 8th grade teacher to say he understands language, or calling his cousin to say he understands language, instead we go this really long circuitous route to get to the videos.
To be fair, we had 2 videos. One was a group video where his solo segment was only 45 seconds, and only that part was published. The other video, I don't remember off the top of my head, but it might have been maybe 2 minutes, 1 minute and 45 seconds, not that long. And then you had 4 Facebook posts. And they weren't lengthy posts. They were literally a sentence on each page. So the state didn't spend a significant amount of time on them. It was just one issue, his familiarity and comfort with using words, and this evidence was relevant to show that he probably did understand words and was not as dumb as he presented himself
But wouldn't
to be.
his confession have shown the same thing? Or his statement to the police have shown his ability or lack thereof to use language coupled with his testimony at trial? Like, isn't that a much better indicator of his ability to use language than, what may have been very lengthily rehearsed videos?
I mean, it's one piece of evidence. The recorded confession might show how he talks to detectives when he's being interviewed about an offense. The rap videos might show how he talks when he's with his friends or when he's comfortable. Like, they just all show different parts. And then his trial testimony certainly probably presented a different picture to the jury. So this, maybe it was a little redundant, I don't know, but it was still relevant, and relevance is a low bar. And like I said, the evidence wasn't lengthy. We had 2 short videos and 4 Facebook posts out of 1,000. But the bottom line here is that the question that Appellant presents to this court about the unique characteristics of the rap genre were never presented to the trial court. And as this court and if this court were to now consider the merits of Appellant's arguments about the cultural aspects of rap music, its potential to racially impact a jury, this court would essentially be considering an issue that neither of the lower courts has considered. And as this court knows, preservation of error is a systemic requirement on appeal. For that reason, the state asks that this petition for discretionary review be dismissed as improvidently granted. And if this court has no more questions?
I have a question. It's sort of going along the idea of confusing the issue. The appellant's name, his MC handle is Block de Fufu. What is Fufu, and why does it need to be blocked?
That evidence was not developed on the
Okay.
record. I have no idea.
All right, thank you.
Hey, please, the court. To answer your question, the prosecutor did ask the defendant about the name, and he basically said it's just a name, it's just rap.
Okay.
So, the state seems to think that what I'm arguing here is different than what the trial objection was. The trial attorney specifically said at the end of his standard 403 objection, he stated, this is vilification by rap. And if there is one word that describes my appeal at both the Court of Appeals and here, it's vilification by rap.
Excuse me, let me just ask one question.
Excuse me?
Are you advocating that we adopt a bright line rule that basically prohibits the state from introducing any type of rap music that they can link to the defendant that advocates for any kind of violence?
Actually,
just
I'm
across
asking-
the board?
I'm asking for a broader rule, anything on artistic impression, which would include rap, that there is a bright line rule, that it has to be directly connected to the evidence in the case.
What if the defendant leaves a false impression on when he testifies? He's a peaceful, law-abiding Boy Scout, and he's creating music that advocates some sort of violence. Why can't the state use that in rebuttal?
Well,
I don't think it's limited to rap. I think there's a recent country and western song that received a lot of national attention about people taking law into their own hands in small towns.
Yeah, try that in a small town.
I'm
Created
gonna,
quite a stir. So,
I'm
I
gonna-
mean, how do we adopt such a bright line rule if a defendant opens the door to that type of evidence?
well, the state is allowed, if he comes in with, it generally comes in at punishment, but if he puts on that he's a law-abiding citizen,
Right.
and then you're saying that you can come in with evidence, that would be different than what's here. The defendant testified he was friendly. I don't think friendly and the rap music, I don't think it addresses that issue at all.
How would we take away the discretion of the trial court under 403 and create a bright line rule to prohibit that from coming in? Because then you're just taking the judge's discretion away.
Let me see if I can get at it this way. In my brief, I state that the use of rap music as evidence of criminality is just as, excuse me, wrong. Wrong. Rap music as a genre, whatever that word is, often glorifies violence, misogyny, crime, and other messages others find offensive. That's why in this case, the Court of Appeals said that the evidence was a slight nudge, and you're using basically something that's just rife with potential for prejudice as a slight nudge. That's not a fair balance of how evidence should come in. And it's my argument here that the prejudice is way up, and the relevance is, as described by the Court of Appeals, a slight nudge as to helping the government prove a critical issue in the case. I'm suggesting they didn't offer it to prove the evidence of the case. They offered to prove he was a criminal general. She argued on, the prosecutor argued on, in her final closing argument, he's the type of criminal that sneaks around in the night.
Can I ask you a question?
Excuse me?
I'd like to ask you a question
Yes, sir.
about the standard that you'd like us to enact in one of our opinions. So let me start with, are you familiar with, I think she's an actress named Kathy Griffin? Have you heard that name before? There's a sort of iconic picture of her, maybe in a negative, iconic way, holding up the picture, holding up the severed head of a former president. Are you familiar with that at all?
Vaguely. I remember some
Well,
kind
what
of.
I'm wondering is if somebody like Kathy Griffin were accused of murdering that person, would that artistic impression of her that she participated in, of her holding up that person's head, be admissible in the trial against her under your standard?
I think, yes, because it's directly, you said holding up the person, she actually murdered the person she's holding up the head?
Yes.
Yes. If she murdered somebody else, no.
Okay.
Yeah.
I just want to understand how far your standard goes, that's all.
Right. Again, I'm down to 5 seconds, and I can't talk that slow. Or fast.
Thank you, counsel.
Thank you.
The case is submitted. Calling now cause number WR94-42001, ex parte Willie Mornell Thomas.
Can I proceed, Your Honor? Yes, sir. Okay, may it please the court, I'm Gary Udashen, and along with Caitlin Gilbert, we represent the applicant in this application for writ of habeas corpus. As the court knows, we're here on behalf of the Innocence Project of Texas. The issue here is an issue that may be obscure to most lawyers, but it's not obscure to the Innocence Project of Texas and people that deal with wrongful convictions, particularly in the writ process, which is what we do. So the issue, as the court knows, is whether or not the knowing use and the unknowing use of false testimony by the state at a trial should have different standards of materiality. And this is an unusual posture that we're in because the state agrees with us. You know, what our position is that the standard of materiality, as this court has applied it for about the last 15 years, should be the same for both knowing and unknowing use of false evidence. The state agrees, and as far as I know, nobody's asking this court to change that. But nevertheless, the court has set this case for this issue to be discussed. Now, the reason why I say nobody's asking for the court to change it is because this is really an issue primarily of application of prior precedent, of stare decisis. And we've briefed this very extensively in our brief. As the court knows, and I'm going to get into some of those factors in just a minute, but as the court knows, the standard that has been applied and is continually applied, and I haven't studied the handout list this morning, but frequently on the handout list, there are cases raising unknowing use of false evidence by the state. And the court either grants or denies those and cites Weinstein. The court doesn't go into further discussion because Weinstein clearly sets out the rule that you've been following for quite a long time now. The standard on both knowing and unknowing use is whether there's a reasonable likelihood that the false testimony affected the judgment of the jury. So that's the Texas standard. That's the rule in this court and in this state. Now, the competing rule is the New York standard, which comes from a 1988 Federal Court of Appeals Second Circuit case from Manhattan, from New York, the Sanders case, where they came to a conclusion that there should be different standards for knowing and unknowing use, and they set out a different standard. What's interesting in the development of this area of the law throughout the country is that when this court decided Chabot, there weren't a lot of courts around the country, either state appellate courts or federal appellate courts, that had recognized unknowing use of false evidence as a due process violation. So this court was probably one of the first courts to do that. That was 2009. Certainly since 2009, there have been a lot of courts that have come to the same conclusion this court came to in 2009, is that is a unknowing use of false evidence is a violation of due process and should be something that can be raised on a writ application to set a conviction aside. And so there is a definite trend in the law, and I think it really appears based upon everything going on in the law, that although the Supreme Court has not directly recognized this as a ground for relief, as a violation of due process, they're going to at some point. All the indications is that they're following the trend that everybody else is following. So the question is really whether you apply
Counsel,
yes,
just I don't want to break your flow, but is Chabot and Whiteside, is our line of cases in this regard, is this a state law basis for relief, or is this a interpretation of the federal Constitution?
I think it's an interpretation of the due process clause.
Okay.
So I think, and what I was getting at, because it does relate to that, what I'm getting at is that there definitely are cases that from other state courts and some federal appellate courts where they say, okay, we're going to recognize that it's a violation of due process for the state to unknowingly present false evidence, and we're going to apply a different standard of materiality to that than we do to knowing, and they just cite Sanders from the Second Circuit in 1988. Without any discussion or analysis or giving any reason, they just treat Sanders, because it's a federal case from the Second Circuit, as the most important case out in the world on this question. And really, there's no reason to do that, and this court didn't do that. This court didn't just blindly adopt and follow Sanders. This court decided what the standards should be on their own, and really, what I would hope would happen with this is that instead of courts, as they adopt this rule in the future, just saying, well, there's a federal court from 1988 in New York City that said there should be different standards, so we're going to do that. Maybe they should be saying, well, the most reasoned opinions and the court that's had the most experience with this issue is in Texas at the Court of Criminal Appeals, and this is how they do it, so that would be persuasive authority. Because, I can't say that I've researched this in every place in the country, but I would be willing to bet that there isn't a appellate court, federal or state, anywhere in the country that has dealt with this question as much as this court. And that's a nature of how we handle these cases in Texas. It's a question, and it's caused because we deal with wrongful convictions in a more robust way than most states in the country. So this court should be the court people are saying, well, this is the court that has the best rule because they have the most experience on this. But what it really comes down to is whether or not the rule should be overruled, whether this precedent should be overruled and be replaced with something like the Second Circuit did in 1988. And this is a matter of application of the Lewis factors on whether this is appropriate to overrule stare decisis. And I'll go through those factors, and essentially, we did this in our brief to a great extent, but every one of those 5 factors weighs in favor of not overruling the precedent here.
Can I interrupt you?
Yes, you are.
So, Do you agree that most of the cases where we have addressed this issue, it doesn't matter what the standard of materiality is, but in this case, the judge recommended granting relief under one claim and denying relief under the new science claim, so it would make a difference. Do you agree with that?
I'm not sure that's true. I understand what the question is I suppose if you overruled the precedent and the standard you adopted in its place for unknowing use was the same standard that is in use on 11073 cases, then it would make a difference. But it's actually not entirely clear what you would do if you overruled the precedent. I suppose you could say we're going to overrule the precedent and we're going to adopt the Sanders rule from the Second Circuit, and if you did that, it's not entirely clear what the outcome would be. I think the only way it would be entirely clear, as you suggest, Your Honor, is if you adopted basically the 1103 standard. That could result in that.
Well, let me ask you a quick question then. On page 23 of your briefing going forward, you say Texas is not alone in applying the same materiality standard to knowing and unknowing use claims. But I haven't looked up all the cases you cited. But are you saying that in these jurisdictions, unknowing use is recognized, or that the same standard of materiality is used in those cases?
Your Honor, we went into our brief and we cited a lot of different states and different federal courts of appeals that now recognize unknowing use as a violation.
Right.
And then we discussed the fact that most of them that have addressed the materiality standard as to whether it should be the same or different, most of them do have a different materiality standard. And like we said in the brief, most of those cases, maybe even all of those cases, just say we're following the Sanders rule. But Nevada in particular, the Supreme Court of Nevada, which we cite in the brief, has done the exact same thing this court has done, which is apply different materiality standards. So as far as courts in other states, Nevada is in line with what you do.
Different materiality standards?
Oh, I'm sorry. The same materiality standards. But it is true there are more courts that apply different materiality standards. But our point was that I know in one of the cases where there was a discussion, it was either Chavez or Weinstein, the question was raised as to, are we alone on doing it this way? And whether you were alone or not at that time, you're not alone anymore, because at least Nevada is in line
Let's
with
look at Nevada for just a minute. Has there been a question presented to their courts about whether that's a good idea or not yet? Or have they just sort of done what we've done so far?
I don't know the answer to that, Your Honor. All I know is that the case where they said it, and that's all I can say. I presume.
So that would put them really kind of in the pocket of like where Texas is today versus what's potentially a better, if there is potentially a better way of handling things.
Well, I understand. I think I understand where you're coming from on that. I think, this court has applied this unitary standard of materiality for a long time, case after case after case, 15 years or so. And this court doesn't just do things without reasoning and deciding that's an appropriate thing to do. I presume the Nevada court does the same thing, that they make their decision, they apply whatever standard they're going to apply because they've considered the alternatives and whether that's the right thing to do. So I assume that's what we're dealing with there.
Well, I think what Presiding Judge Keller pointed out is that, in the cases that we've handled in the past, it wouldn't have resulted in a different outcome were we to have two different standards, if that makes sense. So when you see a case where it might make a difference, don't you think it's reasonable to stop and consider whether a different standard ought to be considered even?
Well, I'm certainly not criticizing the court for considering the question. That's not my intent. My intent really is to say nobody's asking for a change. You know, the Tarrant County DA's office is not asking for a change, so you have before you the parties here where we're in alignment on what the right answer is. I'm not questioning the court's ability or reasoning for asking for the question to be briefed and argued. All right, thank you.
Thank you, counsel.
Good morning, Your Honor. Stephen Conder on behalf of the state of Texas. As opposing counsel said, this is an odd position that we're in because Mr. Thomas presented multiple claims to the trial court, and we did agree that he's entitled to relief under the current status of the law of how we evaluate claims of false testimony. As Chief Judge Keller pointed out, we did not agree on the 11073, and we did not agree on their actual innocence claim. And I can briefly explain why I think those standards are different, or I can go straight into the issue of should knowing or not knowing make a difference. And honestly, I do not believe that the knowledge of the people really makes a difference, because if the issue we have before us was false testimony used to convict a defendant, does it really matter whether or not the people involved knew or didn't know? Granted, if someone did know, if a prosecutor did know, there are all kinds of other things that could happen to them. Particularly, they could be looking for a new position, they could be looking at charges with the state bar. But I think it's is the purpose of this to look at the conduct of the people involved or the actual evidence? Is the evidence that we put before the jury, is that true or false? And so I don't necessarily think that it matters whether or not whether or not the prosecutors knew, and in this case, nobody knew. And I think the court has to understand that this case evolved out of a huge sea change in how we look at DNA mixture cases. As the court is well aware, in 2015, the Texas Forensic Science Commission issued their letter, which advised us that the way we've been evaluating DNA mixture cases was wrong, and that the labs had been doing it wrong because they had not imposed a stochastic threshold to make sure that there were no false negatives or false positives, including the way they present analysis to prosecutors, defense lawyers, and juries in the courts. So this case evolved out of our office going back and re-looking at every case where we did that. We sent out disclosure letters to defendants in close to 200 cases. We agreed to reinterpretations in more than 100 cases, and it went down. And Mr. Thomas is the case where there was a shift in the standards, and it went from he was included on the gun to being excluded from the gun. And to me, that is a very clear change that the testimony that the analyst gave is no longer true. And I will tell you that the way analysts are trained by our labs in Tarrant County have changed because of this action. So this case is kind of a rare duck, and so that is why we're in this very rare position that the state is in agreement on one point of error. But as to on the materiality standards, I agree. The 11073 and what this court has devised in the false testimony are different, and that was an argument this office made to the trial court, was that the difference is the current materiality standard requires no balancing. And whereas
I'm sorry, I didn't hear the last part.
Requires no balancing of the evidence, whereas the 11073 standard, we would look at the other evidence. And as this court is well aware, we do not believe that Mr. Thomas is innocent of this crime. Our position has clearly been that the DNA evidence that we used to convict him, we should not have been able to use it, and that needs to be corrected.
So are you saying, so you're not saying that on a regular unknowing use case that we should add in a weighing of the evidence kind of analysis?
I think we look at it in the regular false testimony thing. We look at clearly how did this evidence impact the jury? What did it play some role? Did it do? And I think that was kind of, if we look at in Chavez, that was kind of in that opinion, they went about how we were looking at this point. But if you look at 11073, I think that clearly has an implied balancing test where we're going to look at what other evidence is out there and compared to taking out this one piece of evidence. And so it creates two very different things. One is simply a due process violation where, okay, we look at this clearly had some impact on the jury because it was heavily argued by us. We know the impact that science has on juries. And then we look at, as opposed to like, if we did a pure 11073 analysis, which the state presented to the trial court, which is, if you look at all the other evidence, there's still, it doesn't mean there's a reasonable probability the jury didn't know about the DNA, they wouldn't have convicted him. And so I think we're looking at two very different theories, and that's why we tried to split it for the court. It was a very complicated decision because we're really cutting some fine lines there. But if we get back to the original question of does the knowledge, I don't think the knowledge really matters. I think it's an issue of, okay, under our current body of law, we have adopted this materiality standard looking at it, and under 1103, we've adopted a different materiality standard. They're very clearly different. And so, and to also to answer your prior question about the 14th Amendment, I think that is how this court has looked at it as a 14th Amendment issue. I think our office in particular has made some arguments in the past about that, that about how retroactive this could be, and this court found that it was all retroactive. So that's, of course, that's not in play in this case because this is a pure post-Chabot case. But it's the state's position that he is an interest of justice entitled to a new trial because we use this evidence that we can no longer use, and that the jury clearly relied upon it, and also the Court of Appeals relied upon it in corroborating the accomplice with testimony. We don't think he would be entitled to relief under 11073, and we don't think he's actually innocent, and those are the points that we
Why
presented.
does the law even ever recognize different standards of review?
Well, I think we have to look at what is the violation. I mean, in terms of false testimony, we're looking at something that's a due process. It's a constitutional violation. Whereas like 11073 is purely a statutory. So we have different standards. So we need to look at them differently.
I mean, does that just beg, that sounds like it just begs the question, though. I mean, you're just saying because it's a statute. Well, that's justification alone for a different standard of review. I mean, there's a deeper philosophical question, I think, that I don't know whether either of the parties have addressed it, but I'm just curious about, why do we have different standards of review for different kinds of issues that come before the courts? And why do we have different burdens of proof? And why do we have, for example, rules that require that objections, for example, to evidence be preserved as opposed to not preserved? Because after all, we could all look at the evidence and decide whether it would have been admissible if the objection came in. So why not? Why not just go ahead and, if we think it's admissible, go ahead and just let it in and not require an objection to review that question later on? I mean, we have standards in the law, and I'm wondering, why do we have those standards?
Well, I think these standards are important for, first of all, to make sure that in most cases we only have to do this once. I think, okay, take your example of the objection. We need to do that so the trial court has the opportunity to correct it at the time. If we're going to look at, on an appellate purpose, we want to look at, okay, where did this violation come from? Are we saying that this action occurred because it's in our Constitution? We're going to hold things to a certain standard for violations of constitutional law. As in this case, we're saying that it's a due process violation under the 14th Amendment. Or are we looking at it as purely, something that the legislature's come up, and we're going to look at it's pure law, that there's not a constitutional requirement that you have these processes in play, but it's our legislature's determined that the people of Texas are requiring us to go through these processes.
Well, are all due process violations the same?
On a broader sense, yes, but I think that's why, but how they might impact the case is why we have to kind of have some flexibility with the standard to look at them and go, okay, did this have some impact on the case such that we lack the confidence, or we feel that it had some undue influence on the people deciding the case?
If the state, for example, intentionally runs in evidence that would otherwise be inadmissible because of some rule of evidence violation, versus the state, manufactures an entire case against someone and calls witnesses that it coaches and tells them to lie on the stand and threatens them if they don't lie that terrible things will happen to them and their family. Are those the same? Should they be measured and weighed the same by the courts?
No, I don't think so. And I think well, your second example involves something that's purely like a state basically engaging in not only just perjury, but also engaging in a complete, basically trampling of due process rights versus the, I'm assuming from your prior example, you're saying something that the prosecutor knows they shouldn't have admitted and do so. I think if it's clear that they should not admit something, then they should be run on the same standard. But if it's something that's an arguable point of law, I think there's a difference between myself and the defense saying, I think this piece of evidence is admissible, they're saying it's not, and later the court states you were wrong, defense was right, versus someone, myself or some other prosecutor deciding this is my guilty person and I'm going to create whatever it is I need to do to get a jury verdict. If the court has no further...
That would not only be a different standard, that would be a crime.
That is
Correct.
also true. That is also true. It would be a
State and
crime.
federal.
It would also be an ethical violation.
So you wouldn't really need a different standard then, because the prosecutor could be prosecuted in one case and not the other? Because after all, there's already another remedy out there for what the prosecutor did?
Well, what I'm saying is I think that, if the standard is if he violates people's due process rights in that way, I think that's a much more clear cut that case is not arguable whether or not it has any type of materiality. If we've created a case out of whole cloth versus an argument where we have a questionability about its admissibility. And that, I don't think, again, that's why we look at how material was it to the jury, how much effect it had on the jury to determine if it involves reversal. I think what the second scenario you're describing involves something so far beyond that, it does delve into criminality, whereas your first example would not be criminal behavior on the part of the prosecutor, just simply that they were wrong on the law.
I have a question.
Yes, sir.
Mr. Udashen said that even though the Supreme Court has never recognized yet a due process violation for the unknowing use of false evidence, he thinks it's coming. Do you think they will use the same standard of materiality? Or I should ask Mr. Udashen, do you think they would use the same standard of materiality for knowing and unknowing use?
I think that that's where they're going, because what we're looking at is, I mean, again, I think you have to look at the evidence itself and what the power of the evidence versus the motivation. And I don't see in the law where whether the prosecutor had good motives or bad motives, or whether he had any motives at all. It's what that evidence impact is on the case and on the jury.
I understand that argument. And how the impact is judged is what we're considering here. And the legislature has said you judge it based on preponderance of the evidence. I guess I'll ask Mr. Udashen the same question.
Actually, I have a question.
Yes, Your Honor.
You, in your brief, you make an argument and sort of dance around this. Are you suggesting that we need a new standard, that we need to change our law? It seems like you've made an argument for why it is we don't. We don't need to change the standard. We don't need to change the law.
The argument I'm making is I don't think we need to differentiate between knowing and unknowing, because I think that if we create a system where we discover, because in this case, like in a scientific case where the science has changed, nobody knew the science has changed, nobody did anything wrong, but we still have bad evidence before a jury, I think it's easier for that to be remedied if we don't have to say, prosecutor, you did something wrong, or analyst, you did something wrong, when at the time they did nothing wrong.
Sure.
So I think it gives us a useful tool to be able to correct a problem without having a circling of the wagons, and for people to be worried, oh, if we acknowledge something's wrong, then somehow I'm subject to a grievance, or I'm subject to something else. And so I think it allows us a tool to correct convictions that have flaws in a straightforward manner.
Well, the tool is there because we recognize a due process violation in the unknowing use of false testimony. The question is whether the tool is going to be the same as for the knowing use of false testimony. And are you saying that protects prosecutors in a way because they don't have to admit they knew something?
What I'm saying with the knowing and unknown is that I think I think in terms of its effect on the validity of a conviction, it's the same. I think that there are ramifications that if this court were to find that a prosecutor had knowingly done so, I think there are all kinds of personal and professional things that could happen to that prosecutor very different than, but I don't think the impact on the actual case differs, because it's still the defendant being tried on evidence that's no longer valid.
Thank you. Thank you, counsel.
Your Honors, the question, like I said initially, is really an application of the Lewis factors on overruling precedent. And all of those factors clearly, like we set out in the brief, weigh in favor of not overruling precedent. Let me talk about factor number one, which is that the original rule or decision was flawed from the outset, which I think Judge Keller goes to the arguments that you made in Chavez and Weinstein about why the rule should be different, why the materiality standard should be different. A couple of comments, and we discussed this in the brief, but one concerns finality, and I think it is highly significant that the state here doesn't rely upon a finality argument. And I think what we've seen, as you well know, over the last 20 years in Texas, is there's been a rebalancing of how finality fits into the scheme of important considerations in the criminal justice system. And finality is a consideration, but it doesn't override truthfulness and the accuracy of the verdict. And I think that the idea that finality would be a reason to have different standards, I think this case is a good example of the state doesn't rely upon that. And I think in Texas now it would actually be an unusual prosecutor that would argue that the court should not consider granting relief on a writ based where the conviction is based upon false evidence, because finality would trump the fact that the false evidence affected the conviction.
I guess at the end of the, let me just ask you this question. At the end of the day, because you both agree, if there's false evidence presented, how would that put either of you in the position of explaining how did it impact the jury in a different way? If it's false, right?
Well,
if you have a different standard, I mean, how would you ever?
Well,
do you understand my question?
Not exactly, but let me try.
I'll clarify.
Yeah, go ahead.
So,
and let me try.
if you have two different types of false evidence, one knowingly and one unknowingly, and you're put in the position of having to use a different standard for each, how do you ever define how that impacted the jury in a different manner?
Well,
because it's false at the end of the
right,
day.
it's false. The fact that it was knowingly presented or unknowingly presented, the jury doesn't know. It has no effect upon the jury. Nobody tells the jury the prosecutor did this knowingly or the prosecutor did this unknowingly, so it has no effect at all. I do think it's important also to point out that the two cases where there's been some discussion by this court about whether the standards should be different or the same, Chavez and Weinstein, both of those, the court applying the current law, the current standard, found no materiality. And the court didn't grant relief on those cases. So that really goes to the part of this analysis under the Lewis factors is the current law working? And when you look at, we cited several cases where the court, all these cases applying the current standard. We cited several cases where the court has denied relief. We cited several cases where the court has granted relief. Nobody could look at those and say, well, this is too easy of a standard for a defendant to meet. Look at what the court did in Chavez and Weinstein, and look at what the court has done in these other cases where they've denied relief. So clearly it's working, which is probably the overriding consideration on whether it should be overruled. And then part of these factors is does it encourage or discourage inconsistency, which I think goes to Judge Richardson's question, is that it would certainly be inconsistent to take the exact same situation where the state knowingly presents evidence, and you take the exact same situation where they unknowingly present false evidence and come to different conclusions based upon what the prosecutor did.
But that's what most jurisdictions do, right? they use different standards. Once they, in the first place, recognize that there is a due process violation, then they use different standards.
That is correct, Your Honor, that most jurisdictions follow that Sanders rule from 1988 and use different standards. What I'm encouraging you to do is to write an opinion that causes them to look at your opinion and follow your opinion rather than the opinion from the New York court.
Now, I don't want to interrupt you talking about the 5 things you want to go do, but I do want to ask, I don't want to forget to ask you the question that I asked the state. You have predicted that the United States Supreme Court is going to eventually recognize a due process violation for the unknowing use of false testimony. Do you have any reason to think that they would use the same standard, or are you just not going to make a prediction about that? That they would use the same standard for materiality for knowing and unknowing use?
Let me answer it this way. I think when and if the Supreme Court recognizes the due process violation for unknowing use, and they look at the Texas Court of Criminal Appeals standard in your cases, and they compare it to the Second Circuit cases following Sanders and other courts, they're going to say your cases are more reasoned and apply a better rule. So
They hold us in that regard, do they?
that's right. Well, I think it's inevitable that if you look at the standard on this issue from this court, it just makes more sense than what the Second Circuit did. And you know, it's a different time. This is not 1988. The criminal justice system is different. Everybody looks at wrongful convictions differently. And my guess would be the Second Circuit, if they had that to do all over again, would do what this court has done. It's just, this is not 1988.
Are there any cases where we've ever followed what New York does?
I hope not. I'm not aware of any.
I have a question.
Yes.
Big Zill's
Have you
here.
thought much about those jurisdictions that have created different standards? Why did they do so? Do their opinions give any insight into what might be the motivation or the rationale for saying that in one circumstance we're going to apply one standard, in another circumstance we'll apply another?
We have looked at that exact question.
Okay.
And inevitably, those courts over and over again say, we're doing it because the Second Circuit in 1988 did it in Sanders. And that's their reason.
And you're kind of hoping that if we issue the opinion that you're asking us to issue, that then people will do the same thing, but just looking at text?
Exactly. All right.
One quick question. Y'all
Yeah.
filed a motion to supplement the record.
Right.
The record has been forwarded up here. We've already filed it. Do you want us to dismiss the motion?
If you have what we were asking for a supplement of, then dismiss the motion. We don't need it.
Thank you.
Okay. Thank you, Your Honor.
Case is submitted.
Thanks.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.